On a Wednesday afternoon, just after the lunch rush, a service technician named Marcus was driving his company van back from a job in the next county over. 31 years old, 14 years on the road, a clean record. The speed limit on the two-lane highway was 55. He was doing 58, maybe 60. He was thinking about the next call. He almost didn't see the patrol car. The unit was already parked in the gravel lot of a closed gas station, tucked nose first behind a row of juniper bushes, half in shadow. As Marcus passed, it rolled out, lights stayed off, the engine pulled out gently, almost casually, and fell in behind his van at a polite distance. Marcus saw it in his mirror. He knew what was happening. He slowed to 54. He clicked his turn signal on at the next safe spot. The car climbed the berm behind him. Lights on now. Pull over. Marcus seized the van onto the right shoulder of a straight stretch, well off the asphalt, wheels turned gently toward the ditch so a passing truck couldn't push him into traffic. Hazards on, windows down, hands visible on the wheel, engine off. He had done this before. He had read the guides. He had a wallet with license, registration, proof of insurance. He had rehearsed at home in his own driveway the words he would say if asked certain kinds of questions. Tonight, he was going to find out whether any of that preparation actually mattered. The officer walked up, average height, dark uniform, body camera mounted on the chest strap, blinking a small red recording light, name tag Redo Conquo. The officer's voice was calm, professional, almost rehearsed in its friendliness, the kind of voice that tells you by its very tone that the next 30 seconds are going to be more important than they look. Good afternoon, do you know how fast you were driving back there? Right there, the question most drivers answer without thinking. If you're a typical American driver, your gut response to a question like that comes out of the part of you that wants to be honest, that wants to be polite, that wants to be cooperative. Marcus had that part too. He could feel the answer rising in his chest, 45, 58, maybe 60. He could feel the words forming. This is the moment this documentary is about, not because Marcus was guilty and not because he was innocent, because the question itself in the second it is asked is doing real legal work, and most of us never stop to see what kind. Over the next few minutes, you're going to find out exactly what kind. We're going to walk through the question word by word, see why it's asked. See what answering it actually does to your case and learn the calm, respectful phrase that does not give anything away and does not cost you anything. You're also going to see how easily the wrong answer can change the next 10 years of your life. Marcus had a choice. He had a few choices, in fact. He didn't know it yet, but there were 3 doors in front of him, and only one of them closed quietly behind him. Let's start with the most common door. The door almost everyone walks through first. You answer the question directly. Yes, officer, I was probably going about 60, or you guess low. I think I was doing about 55, or you try to soften it. I'm sorry, I wasn't paying close enough attention. All of those are common. All of them feel reasonable. All of them are sentences you have probably either said yourself or heard a friend say. And almost none of them are the right answer. The reason is not complicated, but it is something the officer is not going to explain to you. The reason is that the question, do you know how fast you were driving? Is, in traffic court legal terminology, a confession prompt. It is designed, sometimes deliberately, sometimes just by long habit, to put your own words on the officer's recording device before you have any idea of what's about to happen next. Every word you say after that prompt can become a statement your attorney cannot erase, a statement the prosecutor can hand to the judge, a statement that turns a ticket your lawyer might have fought into a citation with your own signature on it. Notice, by the way, what is not in that question. Did you know you were speeding? That is a different question and a much more dangerous one because it imports the legal conclusion into the question itself. Then there is, have you been drinking tonight? That's a third tier altogether. Then where are you coming from? Where are you going? That is the prelude to a consensual search. And finally, do you have anything in the vehicle I should know about? That is the search question, and we'll come back to it later. But the speed question sits at the front of the list because it is the easiest one for an officer to get a yes on, and because it is the one that most reliably becomes Exhibit A. Marcus, in the moment, did not answer the speed question with a number. He paused, a small noticeable pause. Then he said calmly, Officer, I'm not going to answer that question. I'm exercising my right to remain silent. 12 words. Polite, respectful, no argument, no sarcasm, no claim about his innocence. The officer's expression did not change. Okay, license, registration, proof of insurance, please. Marcus handed them over. The officer took them back to his car. The body camera stayed on. Marcus sat in his van, hands on the wheel, and he waited. Now, before we watch what happened next, let's slow down. Because what Marcus just did is what most drivers think they cannot do. They think it sounds rude. They think it sounds like an admission of guilt. They think the officer will get angry, or behave differently, or treat them differently. None of that is the law. The law is simpler than the feelings. The Fifth Amendment to the United States Constitution says, in plain language, that no person shall be compelled to be a witness against himself in a criminal case. Translated into a traffic stop, that means you cannot be punished for refusing to answer an officer's questions. You can be asked, the officer can keep asking, you can say the same 12 words as many times as you need to. The state bar associations from Ohio to California, the consensus of legal aid offices, and the major civil rights organizations all spell out the same answer. During a traffic stop, you must provide your license and the documents the officer requests. In most states, that includes proof of insurance. Beyond those documents, you have the right in every state to remain silent. There is one common question that interrupts this rule. What if my state has a stop and identify law? The Supreme Court ruled in a 2004 case, Hybel v. 6th Judicial District Court of Nevada, that states may require a person who has been lawfully detained to identify themselves. About half the states have such a law on the books. If you are detained in one of those states and an officer asks for your name, providing your name is generally required. Beyond your name, the right to remain silent is yours. That distinction sounds small, but it isn't. It means the right answer when an officer asks your name depends on the state you're standing in. It means the right answer when an officer asks anything else usually doesn't. Marcus had not memorized all of that. He had the principle, just the principle, and he had rehearsed the 12 words, back to the shoulder of the road. The officer returned. Marcus had not answered the speed question, but the citation when it came was still going to be issued. The officer handed him a printed warning, not a citation, 58 and a 55, a written warning, no fine, no court date, no points. Marcus signed nothing. He took the warning. He asked, "Am I free to go?" The officer said yes, and Marcus pulled away. But here is the part most drivers miss: Marcus would have received the warning either way. The officer's radar or pacing or visual estimate had already locked in the speed before the lights went on. The officer had what he needed. The question, "Do you know how fast you were driving?" was never going to change whether the warning was issued. It was only going to decide what language was going to end up in the officer's report, and on the camera, and later in any courtroom that might have opened. By declining to answer the question, Marcus kept the report factual. By answering, Marcus would have done the officer's job for him. He would have turned a routine warning into a written confession under oath. Let's look at the other Marcus, the Marcus who answered the question. The Marcus who said, on a different stop, a different year, in a different state, "Yes, sir, I think I was doing about 60. That Marcus pulled away with a $187 fine in his hand. He fought the ticket in court. He hired a lawyer. The lawyer pointed out that the radar unit had not been calibrated in the last 30 days. The judge accepted that argument and dismissed the case, almost. What the officer did not mention in court, what the driver's own words had done, was that when the judge went back to read the cruiser cam transcript for context, the driver had already admitted the speed. The judge dismissed the radar portion of the case, but the admission sat in the record. The driver's insurance company, during the next renewal cycle, raised his premium by 22%. The reason logged on the company's internal form was simple: a moving violation had been reported. The dismissal of the case did not erase the admission, because in many insurance systems it is not the conviction that triggers the rate increase, but the underlying report. That is the long tail of a 3-second answer. Marcus, the careful one, kept a clean record. Marcus, the cooperative one, kept a record of his own words that quietly did him harm 2 years later. They were the same driver, theoretically. They were not the same person in the eyes of the system that watches you. If you're finding value in this kind of documentary, here is a small request. If you enjoy practical on-the-road stories like this one, the channel puts out a new one every couple of weeks. Subscribe if you want to keep learning, and turn the bell on so you don't miss the next one. Now, before we keep going, 2 important notes. First, traffic laws and procedures vary from state to state, sometimes from county to county. Some states have specific written language about whether an officer can ask probing questions during a routine stop. Others have not addressed that question at all. Procedures around recording, around dashcam and body cam footage, around the right to review that footage later, all of these vary by jurisdiction. The right to remain silent itself is federal. The mechanics of how it plays out during a stop are usually state-driven. Treat what you've heard here as the general federal floor, and check your state's actual statutes if you want the local version. Second, nothing in this documentary is advice to argue with an officer, to refuse lawful instructions, or to escalate a stop. The phrase we are talking about is not a weapon. It is a courtesy to yourself and to the officer. Use it calmly, use it the first time, and use it on the camera. Then comply with whatever the officer asks that the law actually requires you to comply with. That combination is what keeps everyone safe. Okay, back to our story. Marcus, the careful one, drove home. He didn't get a ticket. He got a warning and a reminder that the next time might not be a warning. The next day, he sat down at his kitchen table and wrote out, on a sticky note, the exact words he had used. He taped the sticky note to the back of his sun visor. He is not a lawyer. He is a guy who drives for a living and who figured out, after 17 years on the road, that the safest answer to an officer's question about speed is no answer at all. Here were the takeaways he ended up living by. Take 1. You are not legally required to answer an officer's questions during a traffic stop beyond providing your license and proof of insurance. The question, "Do you know how fast you were driving?" has no legal answer that you owe to the officer. It is the officer's turn to do the work. Let the officer do it. Take 2. Your own admission, captured on body camera, can follow you into court and into your insurance file. Even if a ticket is later dismissed, an admission of speed is the most difficult piece of evidence for a driver to walk back. The officer did not put it there, you did. Take 3. The phrase itself does not need to be long. It should be polite, it should be clear, and it should be said once on camera. "Officer, I'm not going to answer that question. I'm exercising my right to remain silent." After that, you don't repeat yourself, you don't argue, you don't justify, you follow whatever comes next. Take 4. The only question you also must answer, depending on the state, is your name, and only after an officer has made clear you are no longer free to go. If you're unsure whether you're in a stop and identify state, treat the situation as if you are. Provide your name when asked, decline everything else. Take 5. The officer's tone has nothing to do with the law. A friendly officer can still write a citation. A serious officer can still write a warning. Tone is about the person, the law is about the question. Take 6. After the stop, take 10 minutes to write down exactly what was said. Your memory of the exact wording matters more than you think. The officer's body camera has the words too. Yours will not. Now here is the moment to be honest about what this phrase, calmly and correctly used, can and cannot do. It cannot make a citation disappear. If the officer had radar or pacing evidence, the citation is going to be written. The phrase does not change physics or change a radar return. What the phrase does is keep your words off the citation, off the camera transcript, and off the courtroom record. It cannot prevent a search. If the officer has probable cause to search the vehicle, the smell of marijuana, an open container in plain view, a suspect match from a bolo, the search can happen regardless of what you say. What the phrase does is keep you from accidentally giving the officer a reason to develop that probable cause. In your conversation with him, it cannot prevent you from being arrested. If the officer has probable cause for arrest, the arrest happens. What the phrase does is keep your words from being the probable cause. That, in 3 sentences, is the entire effect of the phrase. It is not a shield, it is a discipline. It is the discipline of letting the officer do his job without making his job easier for him by accident. Marcus crossed into his home county 28 minutes later. He turned off the highway, he passed a school zone, slowed to 20. He thought about the warning sitting in his glove box. He thought about the 12 words that saved him from something worse. He thought about the version of him who would have answered the question. That version of Marcus is on the road today. He is in a different state. He just got a $230 ticket. He is going to hire a lawyer. He is going to lose money. He is going to learn, the long way around, that the next time an officer asks him a speed question, he will not answer. Or maybe he won't. A bus passed him on the 2-lane, blowing past the 55 limit by what looked like 10 miles an hour. Marcus glanced at the bus. He glanced at the speedometer. He kept his hands on the wheel. He thought about the amount of attention the bus had just received from the patrol car. The car didn't take the bait. The bus rolled on. Marcus pulled into his driveway. He cut the engine. He sat for a moment. Then he looked at the sticky note on his visor. "Officer, I'm not going to answer that question. I'm exercising my right to remain silent." 12 words. Calm, polite, right. If you've watched this far and you have learned one practical habit for the next time blue lights appear in your mirror, then this documentary did what it was supposed to do. There is one small request before we close out. Hit subscribe if you want more of these on the road stories. Not because the channel needs it, but because the next video will be the one you actually need the words to say when an officer asks you to step out of the car. Subscribe if you want to catch that one when it lands. Stay calm, stay respectful, and the next time the question comes, you know what to say.